I listened to it on my run today. Uh, can we do it Lula Nishmat? It's Yom HaShoah today. So Lula Nishmat,
Absolutely.
all Jews that have died Al Kiddush Hashem, and may their memories be a blessing. So I was listening to a podcast about uh, responses to Amen, and it said, I'll just give two short ideas. Um, People who are not religious or observant who say a bracha, you can answer Amen to, because they're not considered apikoresim. They're just not, for whatever reason, they're not observant, but they're not anti. But you can't answer Amen to an apikoros who says a bracha, or uh, a rabbi of a certain stream of Judaism. Uh, you can't answer Amen to his brocha or her brocha. So I just wanted to mention that. But a non-religious person who says a brocha, who's loves being Jewish, and it just may not be on a similar level of observance to the person they're in front of. Um, not they like that you can respond to.
Okay, thank you. I didn't know that. Um, all right. So um, I'm just gonna share the Mishnah 1 second. We were towards the end, and then we're gonna go straight into the Gemara. Okay. Okay. So in summary, um, by this repeating of the word witnesses, because you could say by the testimony of two or three witnesses, the fact in Devarim chapter 17 verse 6, as well as Devarim chapter 19 verse 15, it uses this term by the testimony of two witnesses or three witnesses. Um, Obviously, when it relates a case about murder, it talks about the chapter 17 verse 6 shall be the one who deserves to die to be put to death. When you're talking about conspiring witnesses in chapter 19 verse 5, it says by the testimony or two or three witnesses shall the matter be established. Or what does that mean to be established? Established where the first set of witnesses are, that they were not in that given location at that time they said they were going to be in. So it's just showing that it's not about the amount of witnesses, but the sequence in which they appear in Adam Zumabim, and even the fact that they can discount 100 means that credibility, as long as they're more than two, can discredit a bigger set, whether it's a single set of 100 or multiple sets. And we discussed the criteria where the multiple sets can come from, if they set A never saw set B, etc. Then Rabbi Akiva was bringing this point. Well, firstly, there was Rabbi Shimon who said that we know in logic that the reason why two witnesses are executed if they're conspiring witnesses is because the two of them could have determined the defendant get a false death penalty. And since they were enough to convict the defendant, both of them would have to be established as Zommerman, because a single conspiring witness wouldn't have the capacity as a singular witness to put the defendant to death. So both of them would have to be established as Zommerman. However, the case can be dismissed if one of them is established to be a conspiring witness, but in order to get the reciprocal penalty they wish to do to the defendant, they would both have to be convicted by a second set of witnesses as being Zomimim. So that's obvious. So then the not so obvious part is Rabbi Akiva's part, which turns around and says, well, um, the third witness is mentioned so that not so that we should deal more leniently with him, but rather that we deal more stringently with him, meaning you don't need that third witness to convict the defendant. The other two will suffice. So if all three are made to Eidim Zomimim, you could think that the third witness who's testifying lav, his testimony was not needed, so he doesn't have to get the reciprocal death penalty they wish to place on the defendant because his testimony is technically not needed. And Rabbi Akiva says, just like a person is rewarded if they join a group of tzaddikim for mitzvahs, if they join a group of transgressors, they become an accomplice, and they are treated like the transgressors themselves. Okay. And then we having this case with Rabbi Akiva further and said that if you have a case with the two witnesses that one of them was found to be a relative of one of the parties of the dispute, either the defendant or alternatively the prosecution or the plaintiff, let's put it that way, then they cannot provide testimony because they would either be biased towards or against their family member. But it's too familiar in order for them to remain impartial. We said that another witness that would be disqualified is one that chose certain careers. In Sanhedrin, it mentions it in various stuffs, 24 and 27. We said what would be disqualified would be a professional gambler because he might owe a lot of money to one of the parties in the court case, and therefore his opinion as a witness cannot be trusted. He might stand to not have to pay off a debt if somebody gets executed or gets a kickback, something like that. Or if one of the witnesses is a sinner, we don't trust them because their reputation is of ill repute. And we're saying, well, what Rabbi Akiva is saying in this particular case is, even if there are two qualified witnesses left to establish the testimony, if you have any witness that is disqualified, whether he's disqualified because of a reputational issue or being a bias because of a relative, their testimony is invalid. Now, this is not only due to a case of Eidim Zomimim, this is also the case in Deuteronomy chapter 17, verse 6, which talks about a homicide. So in other words, if you've got a group of witnesses and one is disqualified on that basis, they're trying to get the murderer off, so the entire group is invalidated by the third member of their group or a member of their group that is discredited, not as an Eidim Zomimim, but just because their status remains biased or questionable. And obviously, you can relate it back to Eidim Zomimim, that it's not about the fact that you've got valid witnesses left over. It's specifically a case where we seek to get off the murderer in the case of a capital punishment where there's murder. Now, we now go back to this issue of Eidim Zomimim, and even if there's 100 witnesses, and then the second set of two people convict the 100, if 99 are Eidim Zomimim and the 100th one is a legitimate witness, because nobody could corroborate his whereabouts in a different location at the time he's said to have viewed the incident, the entire set do not get the reciprocal penalty as Eidim Zomimim, but they are also invalidated and the case is dismissed. Okay? As far as Rabbi Yossi is concerned, he brings in a different case. He says that that's fine with regarding capital cases, that a third person can invalidate the other two. But in regard to monetary cases, if one of the witnesses is discredited or disqualified for any reasons and there are two valid witnesses, that would certainly suffice. Okay, it's only because we're very scrupulous that nobody gets killed in a capital case that there's an exception. A rabbi or Rebbe, who's known as Rav Yehuda Hanossi, said it doesn't matter. The same rule applies whether it's in monetary or capital cases. The disqualification of a single witness invalidates the testimony of the entire group. And a Mishnah says, but when? So in the capital case, it's saying only if the witnesses warned them immediately before the crime, meaning the murderer. If they participated in their warning, they come to prove that they're going to testify. They're not just merely seeing the event. They're going to be participating in the testimony. So by joining in this warning, the disqualified witness demonstrates now that he's not merely a spectator, but a participating witness. And therefore, because he now joins a group of participating witnesses, if he is found to be disqualified because he's either a relative of the victim or the murderer, or he's a sinner, or he's a professional gambler, or the like, because of his reputation or biases, his disqualification invalidates the testimony of all the other witnesses as well. But he has to have been involved with warning the murderer as to the punishment and the consequence along with the others. But obviously, Rav Yossi said if this witness did not warn them, in other words, that witness was disqualified based on his status, it doesn't automatically invalidate the whole group because he's not considered part of that group. Okay. Now, the question should arise for you. So, okay, we're talking about a capital case here, but Rav Yossi just said, he says that the same thing occurs, that the case, a monetary case is the same, is that even in a monetary case, one witness doesn't invalidate the testimony of the others. So we get that. But Rebbe said, within a monetary or capital case, the minute they're part of the group, whether there's two remaining witnesses, even in a monetary case, their testimony is cancelled if they're part of the witnesses that are prepared to testify. So if there's no warning, what process would they use? So in a capital case, they would have to warn the murderer not to kill the victim as to the prohibition as well as the consequence. In a monetary case, they ask the third witness. At that point, he hasn't been invalidated yet. And each of the witnesses, were you a mere spectator or are you prepared to testify? If each of the witnesses, they're prepared to testify, but one is invalidated, it invalidates the whole group. If, for example, the third one said, listen, he was merely a spectator, then whether or not they found out that he was a relative of one of the principals in the legal monetary case, in that particular case, he doesn't form part of the group. So it's the declaration of a warning is only in a capital case. In a monetary case, they question him as to whether or not he intends to testify or not, and they check his status in terms of disqualification. Because if he intends to testify, but he's disqualified, he invalidates the whole group, even in a monetary case. According to Rav Yehuda Nasi, according to Rav Yossi, it doesn't invalidate the whole group with a monetary case as long as there are two solid witnesses that are left, if that makes sense. Now, we're going to discuss this last part of the Mishnah that says, what's this whole thing about by Rav Yehuda Nasi? But if they did not warn them, in other words, the disqualified witness says did not participate in the warning, he is not automatically considered part of the group of witnesses, and his disqualification does not invalidate the testimony of the entire group. This must be so, otherwise, what should two brothers do who sought to have someone commit a murder? So now we're not talking about there's one brother that's a witness and another brother that's either the defendant or the plaintiff. We're saying that two brothers happen to watch a homicide, and if they both warned the murderer not to commit the offense and as to the punishment and consequence, then the two brothers cannot testify together. And then one of the brothers would be invalidated. But the problem is if they're part of a bigger group, the entire group is invalidated because both brothers decided to warn the murderer. So what would have to happen then is one of the brothers should refrain from a warning and just merely be a spectator. Because if no distinction is drawn on the basis of a warning, a murderer who killed in the presence of two brothers would go free no matter how many other witnesses there were, since that one brother who's disqualified will invalidate the testimony of the remaining witnesses. So according to Rav Yehuda Nasi, as long as the one of the brothers doesn't participate in the warning, the testimony of the other remains valid. Okay. So Lance, does that make sense? I can't hear you. You're on mute.
Okay, I've got a question on something slightly. You said something earlier on that I wanted to just question quickly.
Sure.
Is there a maximum number that two people? You said that for three witnesses, they can, for group against 100, you need three, but for two you got less. Or is it
No.
two for any amount?
No. So what are there are two different verses in Devarim, chapter 17, verse 6, and then Devar, which relates to a murderer. It says on the testimony of two witnesses or the testimony of three witnesses, and it says the same thing with regards to Adam Zomimim on chapter 19, verse 15. In the testimony of two witnesses or three witnesses, the matter shall be established. So both parties require a minimum of two in a capital case. That's perfectly plausible. And even two can testify against 100. That's what it did say in the Mishnah.
Okay, because I thought you contradicted that earlier by saying you need to have three.
No, what
Okay,
we were
right.
saying is the question that came up with regards to three is in a normal case, you would think three are stronger than two because if the testimony is well outweighed by majority, one would think that would hold greater weight. And what we are learning here is as long as there's two, the amount of witnesses doesn't automatically hold more credibility the more witnesses there are. And it's proved in Adam
Okay.
Zomimim, where two can testify against 100, whether it's multiple groups totaling 100 or one single group of 100. And then in a case, a capital case or a monetary case, where there are three witnesses for the plaintiff and two for the defendant, we mustn't be swayed by the amount of witnesses, but more in regards to the testimony. As long as they qualify for two, that's the main issue. And one of the other reasons we learned with three is you don't need three to convict. So if somebody joins and they're found to be a problem, as well as the other two, why would we punish the third one, the last one testifying? Because he doesn't convict on his own basis. The two would be sufficient. And if he joins a group of bad people and he is a bad person himself, he fully gets punished. And then we also learn that the third person can invalidate an entire group. According to capital cases, Rav Yossi said in monetary cases, if one is discredited, the two remaining will be valid. And Rav Yehuda Nasi is saying that whether it's monetary or capital, either way, when one is discredited, then the rest are dismissed. Okay, and then we're saying the reason being is that person can be invalidated by being either a relative or a sinner or their reputation is in question or they're biased. However, he requires the only requirement that he joins the entire set is he's a participant in the warning in a capital case. And the Mishnah doesn't say that, but in terms of a monetary case, what's discussed in the commentaries is they ask each of the witnesses, were you merely a spectator seeing this financial transaction where obviously no warning is given, or are you prepared to be a valid witness? The minute he says he's prepared to testify in court, once they've found out there's an invalidation, which dismisses him as a witness, the entire group is dismissed. That's according to Rav Yehuda Nasi. Rav Yossi doesn't agree. He said the two remaining witnesses are solid in a monetary case. That's the bottom line.
What could happen was the guy's brother's convicted of murder. He joins as the third witness. in order to get the case thrown out of court. Because he knows once they find out that he's a brother or close family, you'll get the case thrown out. So he might join as a witness in order to get the case thrown out of court. Is that
So, firstly, there
that'll
would
work?
be I think it's a great question. I think there are two considerations. I think the first consideration is in order that his brother gets convicted for murder, he would have to warn his brother as to the punishment and the consequence. And very few brothers would convict their other brother by being part of the problem. So the minute he doesn't participate in the warning, he's not part of the official registry of witnesses. Because
He must be my
otherwise,
brother still.
no. But you get what I'm saying? If he's trying to get his brother off, the problem is if his brother's off already, providing nobody warns the brother. The minute he's participating in his brother's conviction, he's defeating his whole point. And he's only admitted as a witness when he testifies, when he warns his brother with Hazroah as to the punishment and consequence. So in other words, in order to get his brother off, he has to kind of convict his brother first. It's counterproductive. Do you get what I'm saying?
No, because there are two witnesses. He did see his brother do it. He might have warned his brother. He joins as a third wheel, knowing he'll get thrown out of court.
No, because according to Rebbe, is that and it only brings this case of a relative according to Rav Yehuda Anasi, Rebbe, is that in order to participate as a witness, he has to be involved with the Hazroah, the warning of the punishment and the consequence. So for a brother to warn his brother that he's going to get executed, and then he in fact is convicting his brother. If there was no warning given, the murderer does not get killed by the Sanhedrin. So he doesn't have to even get as far as invalidating the group. He just doesn't warn this brother. Because in other words, if he warns his brother, now his brother is susceptible to the death penalty, and on technicality he might get off at a later stage. But they wouldn't let him testify to start with, meaning if it even goes as far as two brothers, then they wouldn't let him testify as part of the group at all. But in order to qualify as one of those witnesses, he would absolutely have to make his brother susceptible to being executed by warning him of the consequence. Do you get the issue?
So
So I'm saying two separate things. The first thing is that at the very least, in order to be inducted as a witness, that witness has to be participating in making the murderer eligible for execution by providing a warning as to the fact that it's prohibited and the consequence. Now, very few brothers would do that to the other brother, which now makes the other brother susceptible to a capital death penalty, which he wasn't if they never warned him. So that brother generally would abstain. If it's some plan that he quickly wants to warn his brother in order that he gets discredited and invalidates the entire group. Okay, let's just say that's the case, that his brother's quick thinking. Then they might not on that basis even allow him to testify to start with. In other words, it's much more of a difficult case when you've got two brothers that happen to warn somebody. When there's a relative of the protagonist, that person isn't even allowed to testify, which is why in a divorce case, Tosfot says it's difficult because in the get-in process, you have to actually be there to testify as a relative as to the divorce, but you can't testify as a relative to be a witness. So they're pre-designated. The ketubah is pre-designated in terms of the witnesses, and so is the get-in process. So in other words, before there's admission in terms of the court, no relative would be able to testify. It wouldn't get that far. The only time it would get a bit further is if you have two witnesses to the crime of that wasn't related to either the victim or the murderer. In that case, they could cancel each other out. But in this particular case, they wouldn't even be inducted as a witness. Do you get what I'm saying? So the question is, how does the Gemara deal with it? And the Gemara is going to deal with it by saying, if you've got two brothers, in order not to ensure they get convicted, one has to abstain from a warning, and the other one has to warn in order to be included in the testimony. Because if both brothers warned the murderer, then in that particular case, the murderer would automatically get off. So Lance's question is, well, then surely as somebody that's about to murder, his brother would just appear as a witness if he was in fact a witness. And what I'm saying is he wouldn't be inducted as a witness to start with, because any of the principals in the matter would, their family members are prohibited from testifying because of the bias. It's different when you've got two witnesses that are not biased towards the defendant or the plaintiff. It's a different case. They don't have a bias. Furthermore, does that make sense, Lance, what I'm saying?
Yeah.
Okay. Now tell me if it doesn't, because it makes sense to me. Tell me if it doesn't. I'm happy if you're not sure.
Yeah, they should throw it out. They should do their due diligence before and throw it out.
Yeah, they do. With two witnesses that happen to be there, you could have two brothers that are gone for coffee and witness something, but they immediately do due diligence in terms of the witnesses. Are they related to the plaintiff or the defendant? Automatically, it's a screening process. And also, the one thing that the Gemara doesn't address that I'd like to ask Rabbi Cohen is, why do they have to be admitted at all? Aren't they screened before? Why are they only screened at the point of trial? And maybe they are screened before. So this is the problem that you and I have, Lance, is I'm not quite sure, because the Gemara hasn't dealt with it directly, at what stage the screening process happens. Is there a pre-screening before they testify, or is there screening to invalidate them occur in the actual trial? And the reason why it might be in the actual trial is they want to get the murderer off. They want to have some reason to discredit the entire group. Although I don't see what the point of it is if the person's going to get the Bavli treatment either way. In other words, if the brother isn't convicted because he didn't get the right sort of warning, it's very possible that the Sanhedrin won't kill him, but they'll do the Bavli treatment, which case he does. So I'm not quite sure I understand the point of they're calling it a Sanhedrin that doesn't murder in 70 years is a clean Sanhedrin, or once in 70 years is a do you get what I'm saying? I don't get it if the Bavli treatment is still in effect. I understand why the Bavli treatment is in effect, because you don't want somebody to get off on a technicality and be dangerous to society. But it does seem that why doesn't the Sanhedrin just go ahead and form a conviction? Why do they need this concept of groma in indirect? Makes sense. Guys, any questions? Any of you? The screen's freezing. Are any of you with me? You're not with me? You have questions? Gav?
No, I'm good.
All right. So listen, we've got 10 minutes. We could actually go through the Gemara, but it's actually, we've done the Mishnah. It's all been completed. So I think at the end of the day, let me just check if there's one or two things I just want to cover. Otherwise, so look, so the bottom line is you don't become a witness by merely seeing the event. You actually have to agree that you're prepared to testify. Does that make sense? Because otherwise, if two brothers saw an event, they would just cancel each other out and invalidate the rest of the testimony, and a murder could go forward. So you have to participate in a warning, or else in a monetary case, you'd have to say that your intention was not to testify if it was two brothers. Otherwise, the one would be invalidated of being a relative to the other. Okay, guys, I'm sure it's fairly clear.
Damon, just a question on that. Everything is relative in life.
Yeah, everything.
So, but that's not my question. Hey, is that right, Damon? Gavin?
Yeah,
Well,
yeah. I don't want to
So,
start. I don't
but
want
so,
to
no,
start.
seriously, on a serious matter,
I don't
what
want to start the
happens,
Gemara
Damon?
today. Yeah.
No. Just a question on this. I know I like joking around, but I sometimes do ask a serious question, which is going to come now. So I know otherwise Gavin will be
Sometimes.
very disappointed with me. So if let's say, okay, so if someone viewed the incident and doesn't want to testify, can the court force them to,
In other
or can
words,
they be charged?
can they be
Yeah,
subpoenaed?
yes. I mean, unless a person's a relative, then that's no go.
I have no idea if somebody can be subpoenaed or not. I'd have to ask Rabbi Cohen or Rabbi Goldschmidt. In English law, a person can be subpoenaed.
And they have to appear, otherwise they can be in
Failure to
contempt of
appear
court.
can be attempt of court and imprisonment.
but does it make sense here? I'll tell you why. Well, let's talk a murder case. I haven't thought it through on the monetary case. But in a murder case, you would have given a warning in order to, you can't be subpoenaed unless you gave a warning. And you wouldn't give a warning unless you intended to participate in the case. So I don't think it'll be an issue. I don't think you'd need a subpoena in a murder case.
So I think in a murder case you are correct, although somebody might be forced to be subpoenaed in order to get the murderer off.
Yeah, but then they wouldn't have given a
In other
warning.
words, hang on, there might be other rules with regards to exoneration as opposed to conviction. For conviction,
that's-
Gavin, you're 100% right, but because
Yeah.
they try to get the murderer off, for exoneration, they might allow for subpoenaing a witness as opposed to conviction.
Does that concept exist? Exoneration.
Well, it might. It might. I'm saying it's not impossible that it doesn't. It's certainly for conviction, they do these measures to disqualify the whole group of witnesses based on the credibility of one to get the murderer off. So if there's a way to exonerate the murderer, they might subpoena a particular witness. It's possible. I'm not saying it's true. I'm just saying different rules might apply. Gavin, I'm not sure. My guess is as good as yours. In terms of a monetary case, it's very possible that somebody could be subpoenaed because they don't have to participate in a warning. But if by that token, there's a commentary in the Gemara that says that person would say that they're prepared to testify, it would seem that they can't be subpoenaed against their will. However, in a monetary case, maybe they can. Maybe by breaking a negative commandment of the fact that you can get an innocent person convicted or made to pay, maybe failure to appear in court results in Makkos, in lashes. In Makkos, in lashes.
Yeah.
Do you get what I'm saying, Gavin, in a monetary case?
So I think in a monetary case, I would think it does exist, but let's see.
Yeah,
find
and I'm
out.
not sure if exoneration would be a principle. I'm just saying it might be a different principle to a conviction. I have no idea. No idea.
Well, let it play out. Let's see. It might come up somewhere.
Yeah.
And you said also, like, let's say if it's a murder case and it's not clear cut that the defendant he might be innocent and they need to call a witness. The court tries its utmost to try and not convict. Is that, you said that? And if possible to,
Yeah.
not.
Yeah, I'm saying I don't know. I'm saying it could be. I'm not quite sure because how the Gemara is set up is you don't get to learn all the facts. It's basically teaching principle by principle and showing all the issues that can come out. Why Gemara is taught like that, I have no idea. I don't build the cars. I just like to do driver's ed.
Yeah, and if you so and yeah, and
Yeah, I don't know, Kev. I promise you, I have no. Yeah. So maybe it's something I need to ask Rabbi Cohen about because I'm just what I do is I go through the commentaries of the Daf, etc. And then in terms of a broader perspective, I don't know, I can ask Rabbi Cohen.
Well,
All right, guys.
For legal questions, why don't you ask him Schottenstein now? Because he's a legal mind. He's a legal,
For one particular
I'd say
reason,
expert.
I say is an absolute expert in Makkos, Rav Simcha Steinhauer, because he's done 138 shiur in it, shiurim on it, and he trains groups at Mahashan at his home via Skype and live. But the thing of it
Okay.
is, this might be a broader context in terms of Shas, and Rabbi Cohen has memorized Shas, and therefore it might be
Memorized.
yeah, he
and
gets tested.
and,
Yeah.
and going back to that Rov, that Simcha, what is his favorite bird of prey? Now, Gavin, do you know what it is, Damon?
You've got me.
Eagle, because he's a legal eagle.
Okay.
Way too difficult. It was harder than the old shirt. What are you talking about?
Yeah, that was
All right.
harder than the shirt. Kevin's giving the shirt next time. I can't even
Yeah.
cope with
No,
that.
no, not in your.
That's brilliant.
So,
All right, guys, just have a wonderful Shabbos.
Yes.
And
I'll just tell you something, Arthur. Can I just yesterday? Yeah, thank you. It was during the day. It was 35 degrees, and the air was dry and hot. And now it's 21 degrees, and it's going to be so. Arthur, it's going to be cool tonight. This weather's like weird weather. It was like boiling hot yesterday, and now it's going to be cool tonight, Arthur. So just keep a sweater at hand or a sweatshirt, Arthur. Okay, Arthur.
The fire's under control.
Yes, Adam Beit Shemesh. Yeah, it didn't go to I sent messages to my friends. It was in the forests on the outskirts of town, on the outskirts of the city. So it didn't go to the residential areas. Yeah.
isn't
I
that
saw
where
that.
Chili Bar Chaim lives?
Yeah, they live in Ramat Beit Shemesh and Neil Hessen does. They're very blocked, but it didn't
No, but
affect the residential.
he often walks in the forest, Chili. He goes and walks.
Correct. Yeah. Or yeah, but it didn't come close to well, let's say certain parts of the residential areas.
Sure. What caused it?
No, that was that heat yesterday, and some geniuses throw a cigarette back without thinking,
Deliberately.
yeah, I don't know what ignite what, but it was boiling hot, and the air it's like a wall of hot air, and the breeze was hot air, not cool air. It was very weird
Weird.
yesterday, like at midday.
Okay. Well, thank God it's under control. All right,
Yeah,
guys. I'll
absolutely.
see you on Monday. Be well.
Scarf. But then Damon, next week's Yom Ha'atzmaut, next week Thursday. So I'll just I might be doing something, maybe Arthur also. It's a public holiday here.
No
We'll
problem.
discuss it next week.
Yeah, we don't have to do Thursday if Thursday doesn't work for you. It's fine.